Well, good morning. This is Steve Bonoff with Printing Industry Midwest. And I again forgot to not wear something that strobes when I'm doing a webinar. I just can't get that down. One of these days I'll remember not to wear something like that. Anyway, welcome to PIM webinar. Obviously, we're holding these on a regular basis now. I know you're getting a little bit zoomed out. So this program is going to be recorded, of course, and for your viewing later on, anytime, as well as the slides will be made available. I want to do a couple housekeeping things first. Although I know you've been on a lot of Zooms, this is in particular a webinar versus a regular meeting. And so you have an option at the bottom of your screen called Q&A. So we would like you to use that when you have questions for Tom or for Paul on today's program or from the PIM staff. So that would be the best way to ask your questions is through that Q&A. But initially, we're going to offer you an opportunity just to share a little bit about today's program before we get started. So today's program is on labor and employment under our new administration, and we are very happy to have Tom Revnew, a longtime member of PIM with Peters, Revnew, Kappenman, and Anderson, and also Paul Gutkowski, who is going to be our supporter here as we address issues of OSHA and other environmental health and safety issues on today's program. But we are curious to get what your opinions are and why you kind of showed up today and what your concerns are. So I would love if you would just drop into the chat and answer the question that I've just posted, which is share just one or two primary concerns for potential changes in agency policies, regulations, laws, or directives from the new administration. What are you concerned about? What's might be keeping you up at night, or what things are you trying to make sure that you can stay up on? I know that for me, I just recently discovered that the Biden administration actually mandated against industry recognized apprentice programs. I just found that out this week, and I was disappointed because I don't think that's the right strategy. So that's something that I'll be advocating for directly with the administration. And I know there's many other things that you are concerned about as well. So if you have any questions, you'd like to just chat them in, use the chat for that. I appreciate it. And do that anytime as it comes up. But I'd like to welcome Tom Revnew now. And Tom, you kind of take it over and share your thoughts on the incoming administration and what people should be aware of.
Thank you, Steve, and good morning, everyone. Thanks for joining us on today's webinar. And of course, anytime there is a change in a presidential administration, you see a lot of changes in labor and employment laws or the enforcement by the regulatory agencies. And of course, oftentimes at the very beginning of an administration, as attorneys were drinking from a fire hydrant, trying to figure out what's going to happen going forward and how can we best advise our clients on how to anticipate some of these changes. And so today we have essentially a 1-hour webinar, but we have a lot of information packed into today's webinar. So what I want you to know up front is some of the information on these slides I'm going to cover relatively quickly in the interest of time, but the slides will be available for you after today's webinar. And so you'll be able to go back and refer to some of the information that I referenced. But I'm going to start off, I'm going to talk about what's going on with regard to the federal agencies. And of course, with any administration, there's a change within the leadership of the federal agencies, and the federal agencies are the enforcement arms. They're the ones that determine how they're going to interpret the laws, how they're going to enforce the laws, and perhaps what type of rulemaking they're going to come up with to further strengthen the laws as they believe they should be interpreted. So as you can see, I'm going to talk about what's going on with regard to Homeland Security, the Department of Labor, OSHA, the National Labor Relations Board, the EEOC, and I'll touch a little bit on some of the executive orders that were issued, have been issued by President Biden, some of the more notable federal legislation that's pending before Congress right now, and then just a very short snippet on the Supreme Court. So with regard to federal agencies, the first item to talk about is the Department of Homeland Security. And of course, with regard to Homeland Security, really what I'll be driving at is, how are they going to enforce I-9 compliance? And of course, as I think we all know, with regard to the change from the Trump administration to the Biden administration, we have a entity that's going to be more friendly towards unauthorized workers and how they address the unauthorized workers in the U.S. And that starts with the new Secretary of Homeland Security. And so just a few months ago, Alejandro Macorís was confirmed by the Senate. He's the first immigrant and the first Latino to hold this position. He previously had experience as a Deputy Secretary of the department. And of course, he spent a lot of time within the agency addressing immigration-related issues. From an employer's perspective, I think what we're going to see, and I think we've already seen, is there's going to be a significant cutback on I-9 compliance. As you may recall, if you've attended webinars that I've done in the past, I've encouraged, and I still encourage employers to make sure that they do a regular audit of their I-9 compliance. I think you're less likely to see audits being conducted by Homeland Security. You may recall under the Trump administration, the number of audits increased, I want to say, fourfold during this administration. I think you're going to see a pareback of that significantly. So we're not going to see the workplace raids that we saw under the Trump administration with regard to Biden. And of course, as you know, there are issues with regard to border security and how that's being played out, depending on what side of the political fence you sit on, as regard to whether there's relaxed border security or not. But from an employer's perspective, the primary thing that I think you need to be concerned about is I-9 compliance. And if you weren't aware, earlier this year, Homeland Security essentially announced that they're going to continue the flexibility with regard to allowing employers to meet their Form 9I requirements due to the COVID pandemic through May 31st of 2021, which essentially allows you to review somebody's I-9 remotely. So if they're working remotely, you can look at their I-9 remotely. As soon as that employee is able to work in person, then you should be physically inspecting the documents to ensure that they're authorized to work in the United States. But right now, if you still have employees working remotely, you're hiring employees that are working remotely, and you're going through the onboarding process, you can review the I-9 documentation remotely. As soon as they come onto premises within 3 business days, then you should be reviewing their identification documents physically and updating that I-9 form by noting that they were physically inspected and the date. And of course, when you inspect them remotely, you should note inspecting remotely due to COVID. So keep in mind that you can still do the remote I-9 compliance if you have employees that are being hired and are working remotely. With regard to the Department of Labor, I think we're going to see some very significant changes as it relates to the Department of Labor. And many of you have heard that we have a new Secretary of Labor, and his name is Marty Walsh. Marty is a former union member and president of the Laborers Union out of Boston. He is the first union member to lead the Department of Labor in nearly 50 years. And you can see his history is that, he was previously the Secretary Treasurer and General Agent of the Boston Building Trades Council. Then he was elected to the House of Representatives in the state of Massachusetts, and he had served as the mayor of Boston for 7 years prior to being elevated to the Secretary of Labor. And of course, he has been confirmed as the Secretary of Labor at this point. And a couple things to note is at his confirmation hearing, he noted that he supports the $15 per hour minimum wage. He supports achieving equity, pay equity for women and minorities. And he has also noted that he will move to hire additional OSHA inspectors as part of being the head of the Secretary or the head of the Department of Labor. And so in essence, I think what we're seeing is we're going from essentially what I would refer to as a business-friendly Department of Labor now to an employee-friendly Department of Labor. So you're going to see a lot more enforcement actions coming out of the Department of Labor. Items within the Department of Labor that will be revisited is, as some of you know, that in earlier this year, while Trump was still in office, the Department of Labor issued a final rule as it related to whether an individual should be properly considered an employee versus an independent contractor. And that's a huge issue, particularly when you're compensating somebody as an independent contractor, because a lot of the issues go to, are you complying with the Fair Labor Standards Act? And of course, a whole host of other obligations that you have under employment law. So at the tail end of the Trump administration, they essentially said that in order to determine whether somebody is an employee or an independent contractor, we're going to look at the economic realities of that position. And the economic realities essentially looks at the nature and degree of the worker's control over the work that the worker does, as well as the worker's ability to gain a profit or suffer a loss as a result of the relationship with the business. The Biden administration has essentially froze those rules from becoming effective. And essentially, the Biden administration has advocated a different approach to determining whether an individual is considered an employee versus an independent contractor. And that's referred to as the ABC test. The ABC test is used out in California. And the bottom line is what you need to be aware of is the ABC test, which Biden is advocating, essentially defaults to it. The individual is considered an employee of the business unless you can rebut a presumption. And rebutting that presumption means that you have to show three factors: that the individual is free from control and direction of the employer, that the individual is performing work outside the employer's business, and then finally, they're engaged independently in the same trade elsewhere. So it's going to be, if the ABC test is adopted under the Biden administration, it's going to become much more difficult for employers to establish somebody as an independent contractor versus an employee. Also, as you may recall, under the Trump administration, the Trump administration issued some guidance with regard to when employers would be considered joint employers for purposes of liability under the Fair Labor Standards Act or under other employment laws. And of course, the Biden administration has said that they're looking at revising or eliminating that rule, which would more likely make businesses liable to employees of other businesses for a variety of things, including under the Fair Labor Standards Act. The one point I want to make note of is I know a number of you in today's audience have contracts with your staffing agencies. And if you do have contracts with your staffing agency, now is probably a good time to review those contracts to determine how you can minimize your liability as an alleged joint employer of that staffing agency. Other items that we're going to see some I think, some fairly significant changes is with regard to OSHA. And the good news is with regard to OSHA is PIM has a very strong advocate, somebody who's here to help you, Paul Gukowski, who's on today's webinar, and he's just a great resource for some of the things that I'm going to talk about today. But things to think about with regard to OSHA is the Acting Assistant Secretary of Labor for OSHA is an individual by Jim Frederick. And Jim is a former member of the United Steelworkers Union. Again, you can see that we're going from a business-friendly environment to an employee-friendly environment. And so I think with OSHA, you're going to see a much more aggressive stance on worker safety. Certainly, you're going to see an increased number of inspectors, both under the state plans as well as under the federal plans. I understand from talking to somebody within MIN-OSHA that they're planning on hiring 2 or 3 new OSHA inspectors this year, which will increase the enforcement in Minnesota alone. And of course, you'll see the same things happening in some of the federal states as well. And I know some of the participants on today's webinar are in federal states. You're going to see a link where OSHA is going to be linking COVID-19 illnesses and death to the workplace more likely, meaning that it's going to be much more likely that if you have COVID in your workplace, that OSHA is going to expect that you record that information on your OSHA 300s. Of course, there's more of an emphasis on personal protective equipment and more whistleblowing protection. Interestingly, when Biden first became president, almost immediately he issued an executive order to the acting Secretary of Labor, which is essentially said, you need to issue revised guidance to employers on workplace safety due to the pandemic within 2 weeks of the date of the order. That's been done. I'm going to talk on that momentarily. Additionally, he noted that he wanted OSHA to consider whether an emergency temporary standard for OSHA or for the COVID-19 was necessary. They are working on that. Today is the last day for the administration to review with both business as well as labor advocates what that temporary standard should be. And so I think we're going to probably hear some more information in the coming days. Certainly they're reviewing enforcement efforts related to COVID-19. They're launching enforcement efforts related to COVID-19 as well as anti-retaliation principles. And they're looking at a multilingual outreach campaign to inform workers of their rights. And so I think you're going to see a lot more employee complaints under OSHA in this new administration. As hopefully all of you know, in the end of January of this year, OSHA issued guidance with regard to mask wearing and other employer duties related to COVID-19. And that guidance is pretty comprehensive. I know Paul with PIM has spent a lot of time working with the membership in developing plans to ensure that you are compliant, not only with this guidance, but also Governor Walz's executive order with regard to working safe in the work environments. And if you're essentially following the policy that was set by the Governor Walz in Minnesota, you're more likely than not complying with this new guidance. But I would suggest, without spending a lot of time on your duties, these slides will be available for you to review. I know PIM has a lot of information on their website as it relates to your obligations and having a COVID prevention program in your workplace. And of course, Paul is always available to assist you on these items. But as you can see, there's a lot of things that you should be doing as it relates to COVID-19 prevention. Paul, you're on the webinar. Do you want to add anything very briefly on this topic?
For the people in Nebraska, we also have on our website a guidance document that they have, a sample written program for their COVID management and control plan from the state of Nebraska. But I think, as you mentioned, if anybody would follow the Minnesota plan, you'd probably be in compliance with anything in the future from federal OSHA. And again, that template is on the Minnesota website. If you just kind of scroll down and you see that icon for the virus, you'll see those template plans. And if you follow those plans, I know Kathy works with me on a lot of the OSHA stuff and COVID-19 items. And one thing that we have been finding is that when we run into people who have plans, they say that they follow CDC plans or federal OSHA guidance or what have you. But in the state of Minnesota, the Minnesota OSHA inspectors inspect what they want to see that's on that template. So you need to look at that template and not go off of other people's opinions as to what you think you need to have. They're very, very prescriptive on that in the state of Minnesota. You follow their template, you'll be in good shape.
And just to add to what Paul said, I'm aware, at least in the state of Minnesota, that MinOSHA has issued citations to at least 70 employers as a result of failing to comply with essentially the governor's executive order and preventing COVID in the workplace. And of course, we're seeing citations being issued under the federal level as well. I just don't know the numbers off the top of my head.
Right, right.
So moving forward with regard to OSHA, other things that I see being revisited is we're going to see regulation by shaming. As some of you may recall, under the Obama administration, if an employer was issued OSHA citations, the administration would publicize the names of those OSHA violators and put them on their website, issue press releases, and what have you. I think we're going to see that, see an uptick on that as well. With regard to OSHA fine increases, under President Obama, we saw OSHA fines increase by 78%, and he introduced annual increases to account for inflation. President Trump didn't change that policy, and so I expect that those penalties are going to continue to increase to account for changes in inflation. And then the last big item under OSHA is I do foresee that we'll see the anti-retaliation rules being revisited. Some of you may recall where under the Obama administration, they were discouraging employers from having safety incentive programs with the belief that the safety incentive programs discouraged employees from reporting work-related injuries, which would then lead to those injuries not being recorded under the OSHA 300. I think we're going to see OSHA revisiting that. I also think that we're going to see OSHA revisiting electronic submission of your OSHA 300 forms. I haven't heard anything yet, but I anticipate that's something that's going to happen under this new administration. Other items, the National Labor Relations Board. Cover this somewhat quickly, but right now the NLRB is now being chaired by Lauren McFerrin. So as soon as President Biden came into office, Lauren McFerrin became the chair of the NLRB. She is a Democrat by history. She therefore would be considered more friendly to labor issues. She's essentially worked for the government for most of her career. She was previously Ted Kennedy's attorney and worked with him on the Senate Committee for Health, Education, Labor, and Pensions. She'll be in office until at least December of 2024. And so she has a significant say in what cases are heard by the NLRB. There are currently 4 members sitting on the NLRB of a 5-member board. And if you look at this slide, you can see that essentially there are 3 Republicans to 1 Democrat. So right now, we don't see any significant changes with regard to the direction of the NLRB until at minimum when Bill Emanuel's term ends. in August of this year. And as soon as he falls off, I would fully anticipate that President Biden would try to appoint 2 Democrats to the NLRB. And at that point, you'd see a change in the direction with regard to how decisions are issued. Keep in mind that on the NLRB, there are 5 board members, and typically speaking, 3 are appointed from the president's party and 2 are from the opposition. And so I see that changing at the earliest in September of this year. There's been a lot of controversy with regard to the NLRB as well. The acting general counsel essentially took over for Peter Robb when he was terminated by President Biden. There's a lot of concern that when President Biden terminated Peter Robb, the former general counsel, he acted in an unfair manner, an unlawful manner. And so we're seeing a lot of decisions that this Peter Sung Orr is taking being challenged by employers, essentially saying that he's acting without authority because of the unlawful termination of Peter Robb. We'll see what happens, but Peter Sung is considered to be much more of a worker advocate than his predecessor, Peter Robb, who was an employer advocate. There's been some notable NLRB decisions that I think we're going to see reviewed as soon as there's a full complement of Biden appointees on the NLRB. And a number of them could impact you as businesses. The first is, as you may recall, under the Obama administration, there was an issue with regard to what you could do during an investigatory interview. There was a case where an employer during a sexual harassment investigation told employees that they couldn't talk about the investigation, asked them not to talk about the investigation so that they could protect the integrity of the investigation. And when one of the employees went out and talked about the investigation, that individual was terminated because it interfered with the integrity of the investigation. And the Obama NLRB said that's unlawful. You can't prohibit employees from talking about that. And so there was a period of time where employers weren't telling employees during an investigation not to talk about the investigation because they were afraid of violating the NLRB, or the National Labor Relations Act, I should say. That was reversed under the Trump administration in this Apogee retail case. And I think this case may come up, or this fact pattern may come up again under the Biden administration. We'll see. Many of you remember that there was a case called Purple Communications, which essentially said that employees had the right to use your electronic devices, your email systems for union-related items such as union organizing. And that was overturned by a case under the Trump administration, the Caesar Entertainment Corp case. I think we're going to see that case revisited. And then there's a case for those of you who are unionized where there was a case under the Obama administration that said that if a contract expired, collective bargaining agreement expired, you had to continue to deduct union dues from employees' paychecks, even though you didn't have a contract. And that case under the Obama administration overturned probably 60 years of prior precedent. We returned to the status quo under the Trump administration, which essentially said employers do not have to continue to deduct dues, union dues, when a collective bargaining agreement expires. And I think we're going to see this case revisited under the Biden administration. Final case, just to cover really quickly, is the Trump administration provided employers with greater protection to deny non-employees access to their property when they allowed non-employee access for other charitable or civic commercial related activities. We'll see what happens with this particular case, but the Kroger Mid-Atlantic case overturned quite a few years of prior case law to the contrary, that if you allowed non-union entities to come onto your property, such as the Girl Scouts or the United Way, and it gave them access to your property, then the unions could say, look, you're treating us in a discriminatory manner, and we should have access to the property in the same manner as these charitable organizations. The Trump administration board overturned that long line of cases. I think we'll have that decision revisited under the current administration. The EEOC. Bottom line is, with regard to the EEOC, I don't see a lot of immediate changes with regard to the EEOC. There have been some, but I don't see significant changes occurring within the EEOC immediately. President Biden has named Charlotte Burrows as the chair of the EEOC. She's been around for quite some time. She's held positions at the Department of Justice, where she was most notably an associate deputy attorney general. And in her press release, she notes, exactly what the EEOC's mission is, which is to advance equal opportunity for all in the workplace. With regard to the EEOC, much like the NLRB, they have a 5-member commission. And the majority of the commissioners on the EEOC are considered conservatives. The conservatives will keep their majority status until at least July 2022. So don't expect some significant changes in direction with the EEOC. In addition, the EEOC had already approved its strategic plans for fiscal years 2018 to 2022. And so we're not going to see any changes until early next year with regard to the plan. Things, however, to look for within the EEOC. Big topic of discussion is, can employers mandate COVID vaccinations? And in December of last year, the EEOC issued guidance that essentially said employers can require their employees to be vaccinated for COVID-19, and can even prohibit them from coming into the office or the job site if they refuse, but noted that you got to be careful on how you enforce this mandated vaccination policy, because it can't discriminate against individuals with disabilities or religious views. I think we're going to see an update with regard to the EEOC guidance on mandated vaccination policies. We're already seeing a little bit of feedback from the agencies, but in my experience, the vast majority of employers have not implemented vaccination mandate policies. And I think they do that because there's an employee morale issue. There's a potential for legal disputes. A lot of employers are looking at, how do we incentivize employees to get the vaccination versus mandating? We've been anticipating for the last few weeks that the EEOC was going to issue further guidance on incentive programs where employers are incentivizing employers to have the COVID-19 vaccine. Keep your eyes open for that. I expect that we're going to see something hopefully in the next week with regard to what your obligations are if you're incentivizing employees to get the COVID-19 vaccine. And then finally, the EEO1 employment data deadline was extended. We're now looking at, essentially right now is a reporting timeline for the EEOC1 employment data gathering. Executive orders. Well, when President Biden came into office, he immediately issued executive orders, and my understanding is that he has now issued approximately 90 executive orders, which is significantly more than his predecessors have issued, whether it's President Trump, President Obama, President Bush, what have you. He's issued more executive orders than those presidents at this time. A lot of his executive orders are going directly to COVID-related items or employment-related items, and some that will have some fairly significant impact on employers. So he's requiring agencies to look at how they can extend protections of civil rights under the various laws that they enforce. He issued, and not surprisingly, an executive order that if you're going to be on federal lands or in federal buildings, you have to wear a mask. That's not a big surprise. He ordered all executive departments and agencies to identify actions that they can take within their current authority to address the current economic crisis. No big surprise there either. He also issued an executive order promoting collective bargaining for federal employees, and also asked that the director of OPM issue a report recommending how to promote $15 an hour minimum wage for federal employees. Notably, he issued an executive order which essentially directed all the federal agencies to review regulations or policies that were issued under the prior administration that essentially undermined the Affordable Care Act, i.e. Obamacare. So he's essentially trying to reinstitute the policies that provided the Affordable Care Act with protection under how the agencies administered their various rules and regulations. And then a couple final items. President Biden essentially said, look, I'm looking at less regulatory reform. Some of you may recall that one of the executive orders that Trump issued was he had asked all the executive agencies to evaluate federal regulations and identify any regulations that were unnecessary or essentially were redundant or were outdated or inhibited job creation. And when Biden took office, he essentially voided President Trump's executive order and asked the agencies to essentially rescind any of those orders that were implementing or enforcing Trump's executive order. Federal legislation. There are a number of bills that are pending in Congress that give me a lot of concern as an individual that represents employers. And perhaps the bill that's pending that gives me the most heartburn is what is referred to as the PRO Act, Protecting the Right to Organize, PRO Act. And this was a bill that was introduced in 2019 by the House and Senate Democrats. It actually passed in 2020 through the House of Representatives, went to the Senate, no action was taken, and it was reintroduced this year. It was passed in February of this year by a vote of 225 to 206. And with the recent transition of the US Senate to a slim Democrat majority, there's a possibility that this bill will be passed during this administration. And as many of you know, in the Senate, it's 50 Democrats, 50 Republicans, with the vice president issuing the deciding vote. And of course, we all know that she's going to, when she's called in to vote, she's going to break the tiebreaker in favor of what the Democrats are looking for. Under the PRO Act, essentially what Congress is looking to do is to make significant changes to the National Labor Relations Act. And that would be including codifying the quickie election rules, essentially making the quickie election rules statutory law, which would give employees less opportunity to consider information from both sides as to whether or not they wish to be unionized or not. There's a possibility under the PRO Act that it would also eliminate the secret ballot election. In other words, if employees sign a card saying that they authorize the union to represent them, whether they sign that card under free will or they sign that card through coercion, that card would be binding and the union could get in without an election ever being held. The PRO Act seeks to expand the definition of employee and essentially contract the definition of an independent contractor. It would prohibit the employer's ability to permanently replace striking workers, which has been a weapon that employers have been able to use to get the union either back to the bargaining table or get employees back to work, telling the workers that, we're hiring permanent replacement workers if you're not going to return to work. And that oftentimes breaks a deadlock. The PRO Act would take that away. The PRO Act would also require that employers allow workers to use communication devices, such as computers, emails, or phones owned by the employer to engage in collective bargaining or other organizing activities. The joint employment liability would be expanded under the PRO Act. There's an elimination of what's referred to as the secondary boycott protections, which doesn't impact anybody or shouldn't impact anybody on this webinar, but impacts the construction industry significantly. It permit intermittent strikes and slowdowns. So if employees wanted to protest that they weren't being paid $15 an hour and they walked off the job 5 times and then to return, well, the PRO Act would give them protection from being terminated. If you're an employer that's organized for the first time and you and the union are unable to agree to a collective bargaining agreement, a contract, within the first 90 days of negotiations, you'd have to go to a mediator, and the mediator would decide what's in the best interest for you as a business. The law would waive class action waivers signed by employees, meaning that employees would have the ability to bring class action suits against employers, driving up the cost of litigation, driving up the cost of trying to settle a case. Other things that I think are very significant under the PRO Act is the NLRB would increase fines, or would actually allow fines for employers who engaged in unfair labor practice that's up to $100,000. And then finally, I know oftentimes you get concerned whether you're subject to union organizing and you want to be able to consult with your legal counsel and you want to keep that information confidential. And essentially what the PRO Act is saying is, hey, if you seek out advice from legal counsel with regard to how you can respond to union organizing, you're going to have to disclose that to the Department of Labor, and that's going to become public information. So there's a lot of things within the PRO Act that are very detrimental to businesses. And there's a good chance that this could pass under the current administration. Some of you may think, well, we have Joe Manchin, and Joe Manchin is not going to go too far over the line. Well, Manchin has already announced that he supports the PRO Act. And so now we're down to essentially potentially one senator left of the 50 Democrats who, it's unclear whether she's going to support the PRO Act or not. So this law or this bill is very close to becoming law unless the filibuster rule remains in existence. Other things that have occurred, we had the American Rescue Plan Act of 2021 that was passed earlier this year. And of course, the ARPA provided individuals with $1,400 in stimulus payments. It extended federal unemployment benefits through September 6th, allows for tax credits, child tax credits, requires coverage of COVID-19 vaccines, and a whole host of other items. I think from a business standpoint, I think a lot of businesses, and I've heard this from a lot of clients, they're concerned that extending the unemployment benefits and the stimulus packages or the stimulus payments have essentially minimized the ability of employers to get employees back to work. It's what we're stuck with right now. The other thing to keep in mind is the Family First Coronavirus Response Act was extended if you voluntarily decide to do so. At this point, you've probably made that decision, and you should have made that decision. But essentially, one thing to keep in mind is if you did voluntarily extend your participation in the Family First Coronavirus Response Act, you need to keep in mind that it's now clear that if somebody is getting a COVID vaccine or they're recovering from a COVID-19 vaccine, that is now covered leave under the FFCRA. Another big item of the ARPA is there was COBRA premium assistance. And so individuals who lost their jobs or had a reduction in hours may be eligible for COBRA premium assistance. And it doesn't matter if they had an involuntary termination or a reduction in hours that were unrelated to COVID, they still may be eligible for the COBRA premium assistance. And they just need to have a qualifying event, whether it was an involuntary termination or a reduction in hours. And it doesn't have to be between April 1st, 2021 and September 30th, 2021. If they were terminated or they had a reduction in hours, anytime after October 1st, 2019, they may be eligible for the subsidy as their 18-month eligibility for COBRA has not expired. So you need to look and see, did we lay off anybody? Did we terminate anybody? Did they have a reduction in hours anytime after October 1st, 2019? And if so, we should be issuing a COBRA notice to them because essentially what the COBRA notice tells them is that they're eligible to seek premium assistance, which means that you as an employer are responsible for covering their COBRA coverage during the relevant time period, and you will be reimbursed for those premium costs by the federal government through a dollar by dollar credit against your payroll taxes. Hopefully everybody on this call is aware of the COBRA premium assistance. I tell clients, work with your brokers. If you have somebody who administers your COBRA notices, they have probably already reached out to you and you're working with them. If not, if you were unfamiliar, I would advise you to immediately reach out to your brokers to ensure that you are compliant with this change in the law. A few other bills that we foresee taking place or possibly taking place in this administration is Raise the Wage Act. There's a pending bill in Congress where the Raise the Wage Act seeks to increase the federal wage from $7.25 per hour to $15 per hour by 2025. If this bill is passed in 2021, I think there's a good chance some form of a change in the minimum wage will take place under this administration. Additionally, there is what is referred to as the Paycheck Fairness Act. And you have to really dig into the details as to what the Paycheck Fairness Act means for you to fully understand this law. Because when you first hear about the Paycheck Fairness Act, you'll hear that it aims to update the Equal Pay Act of 1963. And a lot of it sounds good, something that we should be addressing. And so some of these items in the Paycheck Fairness Act bill essentially say we're going to allow sex-based wage differentials only where it's based on a bona fide factor other than sex, such as education, training, or experience. But we're going to put the burden of proof on the employer to prove that the bona fide factor is necessary and related to a sex-based wage differential. That sounds, notable. But then you have provisions in this bill which essentially say we're going to prohibit employers from preventing employees from disclosing wages and seeking a prospective employee's wage history. Now in Minnesota and a number of other states, you can't prevent employees from disclosing their wages. Under the National Labor Relations Act, you can't prohibit employers from discussing their wages. But employers often do seek an applicant's wage history, and they use that wage history to determine how they're going to set the wages for the individual that they're hiring. And essentially what this bill would do is it would prohibit employers from seeking or relying on an applicant's past wage history in setting the wages. Additionally, the Paycheck Fairness Act would authorize class actions for wage discrimination violations. It would allow plaintiffs to recover compensatory damages, special damages, and attorney fees. It would allow plaintiffs to recover punitive damages, or the plaintiff can show that the employer discriminated on the basis of sex with regard to wages with malice or reckless indifference. And it would also authorize the Secretary of Labor to level civil penalties and special damages of $5,000 to $10,000 per offense. And of course, per offense, if you have 10 employees, you're talking 10 offenses if they were, paid inappropriately or what have you. So you see some significant teeth being put into the Paycheck Fairness Act, which becomes problematic, obviously, for employers. We also have pending a pending bill in both the House and the Senate, the Family Medical Insurance Leave Act. And the Family Act essentially seeks to provide paid leave to both public as well as private sector employees. If you take time off under the Family Medical Leave Act, essentially this would be this law, this bill, if it became law, would provide workers with up to 66% of their wages capped at $4,000 per month for caregiving or caregiving of a child or for a serious health condition. And we'll see what happens with the Family Act. This is something that has been being introduced in Congress. Boy, I think it's been being introduced for a number of years, but I think there's a good chance that something will be passed under the Biden administration. And then the final topic for today, in the interest of time, is the U.S. Supreme Court. And of course, this has been very controversial with regard to the status of the Supreme Court, depending on what side of the fence you sit on. Former President Trump appointed 3 of the 9 Supreme Court justices, Gorsuch, Kavanaugh, and Amy Coney Barrett. And so right now, there are 6 justices with the Supreme Court that are considered conservative and 3 that are considered liberal. And of course, there's a lot of conversation in the media as well as with the politicians as it relates to stacking the deck or stacking the court, where President Biden is looking at, does he appoint 4 more, does he change the law to allow for the appointment of 4 more justices? And of course, the Republicans' response to that is, well, you're only going to be in office for so long, and once a Republican gets into office, you're going to see the pendulum switch back. So we'll see what happens. A lot of folks essentially don't think that President Biden is going to stack the Supreme Court. I'm not certain what's going to happen, but what we do know is that Justice Breyer, who's age 82, there's a lot of push to get him to retire and allow President Biden to appoint someone new. And we'll see what happens with that. Biden has said that if he does have the opportunity to appoint someone to the Supreme Court, he would appoint a Black woman to the Supreme Court, which would obviously be the first on the Supreme Court. Next oldest justice is Clarence Thomas. He's age 72. I haven't heard anything where Justice Thomas is looking to step down from his role as a justice. So 2 significant cases in the employment law arena that are pending right now is the California versus Texas decision. The Supreme Court heard oral arguments in November of this year, and it essentially concerns the constitutionality of Obamacare, the Affordable Care Act, as a result of the Tax Cuts and Jobs Act of 2017. The lower courts have held that the individual mandate was a critical provision of the Affordable Care Act. And once that was eliminated, they held that without it, all of the ACA, or at least some of it, is now unconstitutional. So expect a big decision coming out of the Supreme Court. Typically, the Supreme Court waits until June to issue their notable cases, and I think we'll see something, well, I know we'll see something in June as it relates to this case. And then second, the Supreme Court heard oral arguments in December in a case involving Henry Schein versus Archer and White. And that is a case where the employees agreed to arbitrate their disputes, and there was a dispute under the arbitration agreement with regard to whether it's the arbitrator who decides whether a dispute is covered under an arbitration agreement, or whether it is a court that determines whether an issue is arbitrable under the arbitration agreement. And so we will see clarification on that particular issue by the Supreme Court sometime this June when they issue their decision. But if you do have agreements, whether they're commercial agreements or employment agreements that have arbitration provisions, always a good idea to make it very clear as to what disputes are subject to arbitration and what disputes are subject to court litigation. It's a lot of information in a very short period of time. I left a little bit of time if you had questions. Certainly happy to take them now. If you have questions, you have a chat box, should be at the bottom of your page. And if you want to just send me some questions, happy to answer them for you.
Thank you so much. I have to say I was a bit surprised to hear so many new potential areas of concern for businesses today. So it's not an easy thing what our members do every day, which is take what comes at them and figure out what to do with it and how to manage it and not do it incorrectly so it causes them fines or problems.
Absolutely.
Yeah.
Yeah, it's interesting times that we live in.
It is indeed. So we are going to, of course, make this presentation and the PowerPoint available in a PDF form to all of our attendees. And so if you have future questions, Tom has his information on the presentation. You can reach out to him directly, or please check in with Chris Davis or Paul Gutkowski and our EHS team. And otherwise, if there's no questions, I don't hear any at the moment, I think we're going to call it a day, Tom.
Sounds good. Thanks, everyone.
Thanks for coming. We'll see you the next time on a PIM webinar.